Thank you. The Board of Appeals and Zoning Department welcome all of you. May I start again? The Board of Appeals and Zoning Department welcome all of you to the meeting tonight. By attending this meeting, we sincerely hope the results are informative to you on how the system handles each application, because all requests are different. Our board members are Chair Francis Liu, Vice Chair Beverly Williams, Kamisha Lowry, Key Jones, Gary Alden, and Sharisa Ingram. The clerk will please call attendance.
Beverly Williams. Kamisha Lowry.
Present.
Key Jones.
Present.
Gary Wayne Alden. Yep. Sharisa Ingram. Present. Francis Liu.
Present. Thank you. At this time, I will ask all members of staff to please stand, state your name and your duties within the county. Please remain standing, and the clerk will place you under oath.
Ms. Harden, do you swear to tell the truth, the whole truth, and nothing but the truth?
Is there any board member who has not received a packet from the zoning department containing the necessary information for our meeting? Our next order of business is to discuss officer elections. Elections are to be held at the first meeting after the commencement of the new fiscal year on July 1st.
Mr. Chair.
Mr. Jones?
It's red. Turn your mic on. There you go.
Madam Chairman, I'd like to make a motion to table this discussion until further. Well, actually, until after we have a training session, which is yet be scheduled.
After the next training session. All right, there's a,
Let me restate, you want to postpone elections until after the training, okay?
and we have a second from Mr. Alden. All in favor, raise your hand. It is unanimous. Elections will be held after the training is scheduled and completed. Our next order of business is to approve the agenda. Are there any changes to the agenda? Seeing none, could I have a motion to approve?
Make a motion to approve the agenda.
And a second?
I second.
Any discussion necessary? All in favor of approving the agenda, raise your hand. Also unanimous. Our next order of business is to approve the minutes of June 6th. Are there any changes? Seeing none, could I have a motion to approve the minutes as written?
So moved.
Okay. Mr. Alden and Ms. Ingram. Legal notice. Has zoning made it possible for all applicants or appellants to receive information of this meeting?
We have.
Have all adjacent property owners within the required limits been notified?
They have.
Was there a notice of this meeting published in a local newspaper to include the meeting place, date, time, and the agenda?
There was.
Is there a copy posted in the lobby of the administration building?
There is.
Thank you. The Zoning Board of Appeals duties are within 3 specific areas. A, an administrative review is an appeal of an order or decision of the administrator or official that has alleged errors. B, the power to grant a variance is given to the Board of Zoning Appeals by the state of South Carolina. Variances may be granted when strict application of the zoning ordinance would cause unnecessary hardship, and the granting of the variance would not cause substantial detriment to adjacent properties or the public good. Special exceptions, C, are permitted uses within a zoning district, but require a public hearing prior to granting final approval. A public hearing is conducted to review evidentiary comments and information, both for and against the proposed application. During the public hearing portion of the meeting, all interested parties will be given the opportunity to speak and give factual information or present factual documentation on the case. Opinion and hearsay are not admissible. All persons wishing to speak will sign the register prior to speaking. All persons speaking will be placed under oath. Anyone speaking will come forward to the podium, speak into the microphone, state his or her name and address, and be sworn in. All information is put on the record. The applicant appellant will speak first and will have an opportunity for a rebuttal at the end. Please limit your comments to no more than 5 minutes. I'm sorry, that's 4 minutes per section 6B of the rules and procedures. That does not apply to the applicant appellant. That is for the public wishing to speak, has the time limit. The clerk will now read the statement of matter as read. If an amendment is needed, please correct the document, initial areas of amendment.
Sorry about that.
That's quite all right. I see that we have just the applicant and appellant wishing to speak. We do not have any members of the public wishing to address this at this time.
Statement of matter is, application is by NR Lodge's property owner, LLC, to appeal the decision of a planning zoning official regarding the assessment and scheduling of payment for school impact fees on 44 apartment units. Subject property is the Lodges at Fort Mill Highway near Rosemont Drive.
Thank you. I now declare the public portion of our meeting open. We will call each speaker to the podium. Mr. Wilson, would you like to begin? Yes, Madam Chair. Gentlemen, if you would like to move up so that we could see you, this is right in our line of sight. That would be great if you don't mind. You state your name and address, and then you will be placed under oath.
Madam Chair, my name is Michael Wilson. My address is 2230 Hassel Place, Charlotte, North Carolina.
And your phone number, please. I'm sorry.
At the house, it's 704-334-1326.
Thank you. If you'll raise your right hand, you will be sworn in.
Mr. Wilson, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Yes, sir.
Thank you, Madam Chair, and thank you all very much for your time this evening. We have sort of a unique issue. I'd like to give you a little context for how we got here and then just frame the issue. I think it will only take about 5 or 6 minutes, and then I'll defer to the planning director, Ms. Harden. So our company is Northwood Raven. We develop, build, and construct, and then we also manage mixed-use apartment communities across the Southeast. We're happy to be a part of your community. This particular project, if you look at the screen that's in front of you, is off of Fort Mill Highway, and we're very excited about the Indian Land area of your county. We think it's a high-growth area, and we're excited to be there. Before I get deeper into the presentation, I would like to tell you the 3 gentlemen that I have with me tonight. If the board does have any questions about specifically the boots on the ground, that may be something beyond what my knowledge or my capacity is, and so I would call on them at the board's discretion. First, we have our local South Carolina counsel from the law firm of Morton & Geddes, Mr. Dan Ballou. Then we have one of our vice presidents of the company and whose primary responsibility is developing this project, Mr. Kyle Whitaker. And then as secondary responsibility and also helping to develop the project is another vice president of our company, Mr. Ron Stewart. So the context is this project has 217 total units. It's unique, and you all may never see this issue come up again. I may never appear before this board again because something happened in the middle of the approval of the zoning, and that is the state of South Carolina and your county developed the concept of school impact fees. The 217 units had already been approved. That's the concept. And again, please, I apologize. I'm a lawyer by training, and I get reprimanded by my wife all the time about speaking down. I'm not trying to do that. I'm trying to establish the record. The 217 is the concept of grandfather. So that has nothing to do really with the argument that I'm going to make before you all tonight. It is the 44 additional units. So it's not uncommon during design that before we begin to build something, we go back and we strategize as a group and we say, hey, this community may want more one bedrooms. This community may want more two bedrooms, maybe three bedrooms. In a large, if we were near a university or a college town, they may want four bedrooms. The younger people sometimes divide it up to reduce the rent by living together. In this particular case, we decided that we wanted to have more units that had one or two bedrooms, smaller units, but after the 217 had been approved, after they had reached the status of being grandfathered. So we came back in a rezoning and we said, hey, we would like to have 44 additional doors, no additional bedrooms, so the number of bedrooms at the community is zero increase in bedrooms, more doors, because we lowered the size, the density of the units. Specifically, we did that where it's green. If you'll see where the planning director highlighted there in green, that's where the garden-style apartments are. And that's really what the discrete issue that we come before you today, and that is the county, through the planning director, has to make a decision. And the decision is, when do we charge the developer the school impact fee? The statute's pretty clear. It's when you pull that first building permit. My argument to you tonight, what I ask you all to consider is that that fee should be assessed not on the 217 grandfathered units, but not until I pulled the 218th door. That's the 44 new. That's the argument that we have. That we understand that it was the 44 came after the statute. We don't argue that the statute's valid. We don't want to appeal the statute. That's already been vetted under South Carolina law. It's valid. We just dispute when it is that we should be charged the fee. As a secondary argument, we would say, and this actually appears, there's a very good analysis that's been provided to the public, to the board, by the planning director and your staff. And if you look, when you get a moment, on page 8 and 9, the bottom of page 8, the beginning of page 9, your staff, your planning department, actually makes my second argument. My second argument is, if you disagree, if you say, no, Mr. Wilson.
Sorry, sir.
Yeah, I'm so sorry.
That, we don't have that for 8 or 9. We have a different for 8 and 9, at least. What page do you have that?
Is this the staff report?
It is, yes, sir. Yes, sir, Board Member Jones.
Okay.
And I can read it into the record. I don't want to waste your time.
I'm sorry. This won't take away from your time.
No, that's quite all right, Madam Chair.
Over here, Pam.
It says 20.
Okay.
You got 2 pages on.
Additional report that we were given tonight, 21?
Yes.
Francis, if you look,
Thank you very much. Okay.
it's got two
Now,
numbers on the same
I'm
page.
literally on the same page with you.
Excellent. That's clever and understood. So my second argument, at the end of the hearing, the public hearing, you all will have to confer and you'll vote. So again, my first argument, what I would like you all to consider is to say, Mr. Wilson, we believe that Northwood Raven and the Lodges project is right. We will ask our staff not to charge you the school impact fee until you pull the building permit that gets to the first grandfather. So I think that I should be able to build 217 units. And you would say, well, Mr. Wilson, why? Why does that matter? The economy. And I have to be candid, we intend to build every single unit that you say we can build. But the reality is, with the way the economy is going, it is also possible we only build 200 units. And so the argument I make means that we would say, hey, we didn't get into those new 44 that were approved. We don't want to pay the school impact fee. That's not our intent, but it could occur. I can't predict what the Fed's going to do with interest rates. I can't predict how popular a project's going to be. I believe that Indian land will continue to grow, and it's going to be one of the most fastest growing areas, not only in your county, but in the United States of America. But that's my opinion. That may not bear out to be true over the next year. The staff makes my second argument. My second argument is, if you don't buy the charging me the school impact fee when I get to the 218th unit, at least look and consider that the area where we made the change And so I have, within there, to be specific, the number of grandfathered units in the green area, and I want to make sure I cite this correct on the record, is 74. I have 74 grandfathered units that were not part of the school impact fee. I have 44 after that. So when I got to the 75th unit, and that's the point that staff makes, if you're going to make a second consideration of my argument, when I get to the 75th unit in the green area, then I believe that I should be charged the school impact fee. And those are really my remarks, Madam Chair. I'm happy to answer any questions. If it's a question that I don't know the background or the basis for, I'd be happy to call on any of the gentlemen that I brought or just take my seat, Madam Chair.
Thank you. We will have questions, but we will hear from Ms. Harden first.
Excellent. Thank you on the board.
Back with questions. Thank you very much. Staff representative?
Good evening. I'm Allison Harden, Development Services Director for Lancaster County. My job is to supervise planning, zoning, stormwater, and building departments. To give you an overview of our discussion, the Lodge's property, as Mr. Wilson explained, is a rental property construction project on 38.88 acres. It is under mixed use, so it required approval of a master plan, which was achieved twice, once in 2021 and again in 2022. The project, as he mentioned, was originally for the 214 units. The increase of 44 additional units was achieved in 2022 with the plan review and increased the density of units per acre. The cottage courts in the blue are 63 units, which have not changed from the beginning to the amendment. And the townhome units, the 80 units in yellow, have not changed from the first plans to the amended plans, but the apartment units did. The development impact fees were discussed midway between the first approval of this project and the amendment of the project. The overview was provided in 2021 and the hearings were held. The date set for implementation was January 1st, 2022, and the map was amended later in January 2022. As you can see on the map, the blue star indicates where the site is for the lodges, and that shows you that the lodges is completely within the impact fee area for Indian land. School impact fee declarations in the ordinance that was adopted indicate that it is a fair and equitable plan to go forward for development in the Panhandle service area to fund new school improvements, in part through a proportionate share school development fee. The fund, Tischler-Bice, did a impact fee analysis for the county, did a preliminary, and then followed through after with a follow-up that was adopted through the ordinance. And all new residential development in the Panhandle service area generates a demand for the school facility system based on the same student generation rate. So all units in the area are indicated as either a single-family dwelling unit or a multifamily unit, and they are charged appropriately per dwelling unit. In addition, the projects that are impacted by the impact fees are shown in Chapter 17 of the Code of Ordinances, and that says that it shall apply to all new development, which is why Mr. Wilson indicates that 217 of his units were not, the impact fee was not applied to those. Those had been previously approved and previously granted approval by not just the council, but the staff had started reviewing the site plan, so those were not counted as part of the review fee. But for new development in places where there is an increase of service units, the impact fees were impacted. We took into account this information plus the sections of the school impact fee ordinance that says the school development fee shall be paid prior to the issuance of a building permit or development activity, and that liberal considerate construction, the provisions of the ordinance will be liberally construed to effectively carry out the purpose and interest of furthering, promoting, and protecting public health, safety, and welfare. So how did we apply the 44 fees when we came around to the discussion? We determined that the 44 apartment units that are subject to the impact fees would be paid for, as we said, as part of the apartment fees came forward. The applicant started applying for apartment building fee or building permits recently, and were reminded that they had the 44 units to be paid for, using the term and implementing it liberally for the benefit of the public health, safety, and welfare. We knew that the 44 units would be required to be paid for, so we asked for that to be paid for. The applicant opposed, saying that they needed the 217 units to go first, or wanted the 217 units that were exempted to go first. And for the cottages and the townhomes, we vehemently disagree that that should be part of the consideration because they are not related to the increase in the units. As for the appeal of the actual payment or being impacted by the fee, there is a process for that in the code that says that the applicant may submit an alternative report for the plan. They also may pay the impact fee under protest, which is what they have done. They have given us a bond for the impact fees, so we have the fees in hand by bond. And if there's a dispute, they go through mediation. The burden of the proof is on the appellant to demonstrate that the director is erroneous. In lieu of calculating the school development fees, then there is a process for that in which they get to hire a qualified professional to prepare the individual assessment of development impact for their project. One of the discussion points was that the single-family bedrooms do not generate population for the school system. That is their right to argue that, but they have to provide backup information with that, and we have not yet received that. And then appealing the administrative decision is what we're going through here. Under formal review, 4/5 of a vote of the board is required. And this is a summarize where we are with the different types of appeal for this. This is our first ever school impact fee appeal. So this is, we're all going through this together for the first time. Staff recommends denial of the appeal. We did the job that the ordinance required using the liberal constraint. And we request that you ask the applicant to provide the required documents for any appeal of actually being impacted or actually being charged the 44 units.
Would you please say that last line again?
We request that when you're making your determination, that you ask the applicant to provide the required development impact study if they want to continue with an appeal on being applied for the 44 units at all.
Thank you. Mr. Wilson, did you want to say anything additional at this time?
One moment, Madam Chair.
All right.
Madam Chair, members of the board, thank you. First, I'd also like to say you have an excellent planning director. I've enjoyed working very much with Ms. Harden. We just disagree on this point. There's no animosity. I didn't want you guys to think that we're at odds. We like being in this county. We like working with Ms. Harden. I just disagree. That last point is a little confusing. I want to make sure we're clear. This hearing, the only thing I have a right to talk about tonight is the timing of when the fee is due. We absolutely agree and stipulate that if we want to have any discussion about the number of bedrooms and doors, we've got to get an economist. I've got to file that. That's not here tonight. That's not, I'm not an economist, and those materials have to be presented to you. So again, before I take my seat, the issue that I brought to the board is very discreet, and that is when are the impact fees due on this project? And I present to you two arguments. Argument one is I would like the board to consider saying, Mr. Wilson, We agree you have 217 grandfathered units, and when you hit 218, you owe the full impact fee. Or alternatively, you say, we disagree with that, Mr. Wilson. We believe that you have 44 additional garden units, and so you had, I want to make sure the record is correct, you had 74 grandfathered garden units. So when you get to the 75th garden unit, that's the green area there, you owe that full impact fee. Thank you very much. And I open myself up to any questions or inquiry that the board may have.
It'll be just a minute, but if you'd like to stay
Yes, ma'am.
standing. At this point, we're going to close the public portion of the meeting. And before I open it up to board members' questions, I wanted to check with Ms. Harden. Now you have me a little bit confused that you only want us to discuss the timing of the fee, not whether it is applicable in your case.
I can explain a little bit of this, that Mr. Wilson's application mentioned 2 points, and I addressed the 2 points in the application. Since that time, and I'll let you speak on that, there's been a discussion over the appropriateness. I didn't hear you say you wanted to back up or drop that first point from this meeting, so I had to continue to address it. But if you said it and I missed it, I owe you an apology.
Yeah, Madam Chair, that might just be a point of confusion. This is so new to everyone involved, myself, Director Harden, even Mr. Blue has done this for years in South Carolina. There's one appeal form that we got off the website. I put all the arguments there because I was afraid if I didn't turn it in, that'd be it, and I would be toast. So again, what I bring before you tonight is just the issue of when the impact fees are due. That other issue, if we want to come forward with that, if we want to keep that alive, that is how you calculate it, what an economist would do, whether you count doors or beds. That is not before this board tonight, and I'm not pushing or advocating or asking for a decision on that tonight. Yes, I'm sorry. The planning directors. Yes, sir.
Oh,
The planning director asked procedurally that I clarify that for this evening, I'm dropping that argument from the appeal because it all appears on one
he is going
piece
to
of paper.
withdraw.
And I would, for purposes of this evening, I absolutely withdraw that. I just had to put them on the one piece of paper that was on the website for the board.
am I to, does that mean that it's possible you will come back to ask if the impact fee is appropriate on the 44 one-bedrooms?
It is possible, but I have to have an economist that supports my argument. I am not a qualified economist. I am not competent to testify before the board on that matter.
All right, so we're just discussing timing. I'm just trying to figure out the cart before the horse, that are they applicable, and whether that would be done, and then discuss timing as opposed to timing and whether they should be at all. But okay, yes, someone went, all right, Ms. Harden, just
I
went,
believe I can help.
all right,
So by withdrawing the request to discuss the applicability at all of the impact fees, the applicant does not remove his ability to come back to you. There is a process to follow for the applicability of the impact fees that requires them to get a report by the economist that says, this is our argument. That comes to me for my review. I review it, compare it with the Tischler Vice report, make a determination. If he doesn't agree with my determination, he will absolutely have the right to come back to you and discuss it at that time. But that key piece of that appeal that is missing is the report.
thank you. Yes, sir, Mr. Jones? Yes, if you,
I turned it off so I wouldn't
there we go.
say something really stupid out loud. I'm sorry.
He and I are good at that.
I'm sorry. I'm an engineer, and I'm kind of got a narrow focus. We all do, engineers. And I see item 1, item 2, item 3, item 4. And that's the way I'm used to seeing us proceed in these hearings. And you've now made scrambled eggs out of that, if I'm not mistaken. Instead of having 4 eggs, I've got 1 scrambled egg. So are we talking about, because I couldn't read this and listen to you at the same time, are we talking about item 1, item 2, item 3, or item 4? Or none of the above?
I can help with that, too.
Thank you.
Under item 1, I'm speaking from page 20 of your packet, page 7 of the staff report.
Yes.
Item 1, applicant appeals from action of zoning official that school impact fees are assessed for the total project instead of specific to the number of units being permitted, and that school impact fees are being assessed on the number of dwelling units. That appeal is the one that the applicant has asked to withdraw for now. And if need be, we'll come back to you after the report has been provided by them and evaluated by our staff, and a decision has been made. Under item 2, applicant has agreed by the action or decision that that is where we discuss that the applicant has asked for the impact fees to be applied at building permit number 218 rather than within the first amount or applied in general to the townhomes. Staff disagrees. We think we did right. And if you think that we didn't do right, we ask that you consider making them pay the impact fees for the apartments at the time the apartments are being planned, rather than holding it back until the cottages and the townhomes are being planned. With the request of 217 units fully being built before the impact fees, that means that the apartment payments would not come in until all of the other units are built. And we disagree with that because the impact fees were applied to the apartments alone, so the delay should be applied to the apartments alone, in staff's opinion. Item 3, contending that the correct interpretation of the UDO is applied to the property, same argument. And item 4, that requests the following relief. The part 2 of that, the school impact fee should account for the unit mix. That also comes from the report that they will be completing and bringing back to staff. So item 4.2 has been withdrawn. Item 4.1, item 3, and item 2 are all wrapped up in the discussion of when are the impact fees applied? And item 1 is withdrawn until such time as the applicant has done the report.
Would you please give those numbers one more time?
Yes, I'll go from the top down this time. Starting back on page 20 of the packet, page 7 of the staff report.
Yes.
Item 1, appeals from the action of the zoning official. Those 2 items are withdrawn so that the applicant can come back with a report, and he will have the ability to reappeal or to reissue that appeal after that process. We don't have the process filled for that.
Thank you.
Item 2, on page 20 of the packet 7 of your report, which continues on to page 8 of the report, page 21 of the packet, and item 3 on page 22 of the packet and page 9 of the report are both discussing the same point, which is when should the impact fees be implemented.
Okay.
The applicant's original argument was that it should be implemented after 217 units in this development are built. Staff's argument is that we did it right by asking for them up front because the applicant is currently pushing for apartment building permits to be issued as much as we can. If there is a compromise to be had, we both agree that we can handle you asking us to apply the impact fees after the first 74 apartment units have been permitted. And then the other 44 apartment units would be, impact fees will be paid. We still have it in a bond. We still have it on hold. They have paid it under not direct, protest, that's the word. I wanted to say duress, but no. May feel like it, but that's not the word I was looking at. So under protest, they could continue on forward with the project at that point. And then item 4, in the same way that item 1 needs a process to be followed, item 4 will be held over, withdrawn for now, come back if need be. Do you have anything to add?
Only.
And do you agree with me?
Generally, yes. The only thing I wanted to say, Board Member Jones, I try to be very, I'm not an engineer, but I try to be very specific as well. This process is so new. There's all those things are there because you guys told me to do it. If you look at the form, I mean, it's really just 2 issues. When do you pay the fee, and whether I've got an economist that says that it should be calculated differently. That's it. But Director Harden stated everything correctly, but that's the form. And so I apologize for creating that confusion, but I filled in the blanks, Board Member Jones, and that's why you got that mound of paper, sir.
And that form?
I know what your
that's all we
problem
have.
is.
And
We don't even have one.
I'm going to ask again to make sure, because number 3 is the only thing that we're discussing, and number 4 is also crossed out. I just want to be 100% sure. The request the following relief,
Madam Chairman,
4. Wait,
Number 3 should be withdrawn as well, now that I've reread it.
okay, then
think
what,
it's-
so we're just item 2.
Well, I think
I'm glad I
it's
asked.
I think it's 1.1. Again, to make it, I don't have that form that you have in front of you, Madam Board Chair, but the point is, all that is before you tonight is I'm asking for some relief as to when the school impact fee would be paid. And I think that falls under like 1.1 and maybe 4.
Yeah.
So that'd be item 1.1. And then I think you drop all the way down to 4.
Right. No, item 2, project approved.
Yep.
117. So, 1.1 is on withdrawal. No, wait, I took that back. 1.1 is up tonight. 1.2 is withdrawn. 2, which only has the one argument, is discussed tonight. That's 3 is withdrawal.
Right, we're not done.
3 is withdrawal at 4.1. That's tonight.
Right.
Oh.
4.2 is withdrawal.
And I'll say for purposes of this record, if it helps at all, Board Member Jones, and Planning Director Harden and Madam Chair, we stipulate the only issue that we're appealing, the only issue we're asking you to decide is when is the school impact fee due, if that helps with any clarity. And then you have the 2 arguments. One, I've asked you to consider first that I not be assessed a school impact fee until I get to the 218th unit because I've got 217 grandfathered units. Or alternatively, I adopt the staff position and say, okay, if that is unacceptable to the board, then I would say that within that green where the garden apartments are, that the school impact fee wouldn't be triggered until I hit the 75th unit because I've got 74 grandfathered units. That's all I have.
Let me
Madam
ask.
Chairman?
Yes, Mr. Jones.
you're saying that is all you're asking for tonight? All right. Allison, does the county agree with him? I mean, what we have here and what we're trying to arrive on a decision on are 2 completely different things. I spent all this time studying this, reading this, and thought I had some things arranged in my mind to understand it. And you're telling me it's all changed and does the county agree with what he has said, that the only thing we're considering tonight is when the impact fees for those extra units is to be paid?
Yes.
That's a correct assessment on my part.
That the thing that we have left to discuss is when do you put the 44 units in
And
payment?
you have already been issued permits for construction on some units?
Yes.
That is correct, but the statute's pretty clear. I had to pay a bond, so I had to gather the money up in a corporate surety bond.
Well, I'm familiar with the
And
bonds.
that bond had to be
Right.
approved by council before we would allow them to have the permits.
And I feel your pain. I took a one-week course in engineering economics early in my career, and the instructor walked in and wrote on the board the time value of money and said, if you don't remember anything else, remember that. And I think that's what you were referring to.
Mr. Alden, did you have a question? Thank you. I have a question, Mr. Wilson. Considering asking for the delay until you start the 75th unit, and we're only talking about the units in the green, is there any situation where you would build 50 garden units and then switch to townhome units and build some and cottage court units? Because then you would be building a lot of apartments, but you would be, if we ruled this way, that on the 75th garden one, that would leave a little interpretation that I don't have to pay until I start the 75th. Meanwhile, I'm building 63 cottage court ones over here. So I just want to be clear that are you only going to build the green apartments, or would there be concurrent development or building?
Madam Board Chair, I want to answer that directly, and I'm under oath, and it is the
Yes.
time value of money. So it's a phased project. It would be very, very difficult to build all of it around and save that. But we would try to maximize the decision you made. If you made a decision, I would try to hit that last unit closer to the end. It's a little bit impossible, but I want to make sure that you know that I would try to not get into the new 44 until near the end of the project. That's correct. But Madam Chair, I also have to tell you in full candor, because there's debt, millions of dollars on this, we want all of it built. It's all going to get
Of course.
built. I want heads in beds. So I respect completely the question. I think I've answered it honestly, but I want you to understand we want to build the whole project and be a good tax-paying member of your county.
Your honest answer troubles me in that, unless I'm interpreting it wrong, maybe you would build some other units before you finished the 74 garden apartments.
I mean, it's phased. I'm not trying to be clever. It's a massive project. It's phased, so there's always different units being built. But again, to directly, honestly answer your question, yes, ma'am, I would want to build the 74 before I got to the 75th. Is that answering the question?
No,
Okay.
because what you would want to do versus what I think this board would like assurance from, that if we were to discuss deferring payment until the 74 garden ones were, I can only speak for myself. This board cannot discuss projects before we come out here. So we're all hearing what we each have to say for the first time, just so you know. My concern would be that we would say, okay, when you start the 75th garden apartment, and being an astute businessman, say, they didn't say we couldn't start the cottage court ones or the townhome. We just said when we hit 75 garden apartments, we'd start paying it. So I would want to be very clear, if we would decide to go with the after 74, that there would be no other construction. It would be just those. I'm hearing consensus from my colleagues that you would build 74 and then when you start the 75th, they would come in, but there would be zero construction of cottage court or townhome units.
Yeah, that's just not how the project is phased, okay? I mean,
Okay.
that's just not.
Okay.
May I? I'm looking at your plans, and I'm looking at how your architecture developer, whoever put this together, your surrounding area where the blue is, that's majority of where you're going to build, correct?
Well, we're going to build it all.
You're going to build it all, but you're going to start there because that's the areas that's already been grandfathered?
The yellow has 80 units. The yellow has 80.
The yellow has 80 and the yellow and the blue has been grandfathered, correct?
That is correct. The yellow,
Okay.
the only new stuff is the green, that's right.
The only new stuff is the green. So with that said, can that not be built without the green being built yet?
I believe the answer is yes. I mean,
I
need
think
to,
so too.
Yeah, but I want to, if you give me just a second, Board Member Ingram, I'd want to ask my construction people, so I've answered your question
Okay.
correctly.
But while you're asking them, I think the county wants the money before any of the construction starts.
I understand, but
Okay.
if they,
Yeah.
But then that would be after,
Excuse me, Madam Chairman, I don't think we can talk among ourselves about them being able to hear us. Am I correct or not?
I do not know because someone was not present. All right, we were just discussing, all right.
Yep, I was-
Yes,
I
sir,
was
go
just-
right
I just wanna
ahead.
ask,
You have the
board member-
floor.
So, Board Member Ingram, I checked with our construction people and our developer. We've already pulled building permits on 5 of the one in green. So we're building in there right now.
Oh.
I just wanted to make sure.
Of
you
which
guys knew that.
ones?
Again,
In the green?
In the
Okay.
green. So I guess what I'm trying to tell you is it's not a game. We're going to build all of it.
Oh, no.
It's just, we're
Right,
just
but-
having a debate about, I just disagree that when the impact fee should be assessed.
So our two choices were, that you have presented, are 218th or the 75th Garden Home, and the county has asked that the choices be, if I recall, and correct me if I'm wrong, that you said the county could live with after 74 garden apartments, that it would either be all due now or on the 75th garden apartment. However, my concern is, to me, I am seeing this as 74th garden apartments, period, not building everything, and that because it is possible that you could end up in the same position without any of this meeting. You could build 63 cottage court units, 80 townhome units, 74 garden ones, and be back with, now we're going to do this 44 additional and pay the school impact fees. And I just don't think that's why we're here tonight. I think we're either here to decide if you had to pay it now before the permits are pulled, which you have done under protest, which is a tool available to you. I don't mean that with any discrimination. Or asking us to decide that the impact fees would not be put on until the 75th, but without any other building. That's how I interpret it. Yes, Mr. Alden?
Let me try to mix things up some more.
That's all right.
Is there a statutory requirement that the fees involved of the additional 44 must be assessed at this point?
That would be Ms. Harden.
That's part of why we're here. In our interpretation as staff, pulling from the code that says that fees are applied before and gathered before permits are issued, we informed the applicant that their fees were due. And the applicant had a different opinion about when the 44 units should be due. And that's why we're here.
Is that hinging upon the fact that South Carolina changed the rules
No,
midstream.
South Carolina didn't change the rules. Lancaster County adopted the impact fees after the applicant had their first permit. So they did it through the public process. They did it through all the ordinances, checked off all the boxes on all the things that should have been done. And at the time that the applicant went forward for the change from the 217 units to add the 44 units, it was discussed at the Planning Commission meeting and the council that that these units might have to pay the impact fees. And between the Planning Commission and the council meetings, the decision was made that not all of the units would be applied. They did not review it as a total redo of the original plan. They grandfathered in the 217 original and only applied it to the 44.
Next question, let me help fabricate it. Just went out the back of my head. Forgive me, let me come back around. No, I know what it is, and I'm sorry for that. Mr. Wilson, can you speak to, or maybe Ms. Harden, you need to, the bond that's been issued under protest, does that include all of the fees for all of the units? Does that make sense? So that's everything.
Yes, it does. The applicants have paid all of the fees that they're required to, including the public safety impact fees. The ones that are under protest are the school impact fees.
Okay, so what if, and I really need some help with this, what if we accept the bond, not we, that the bond is based on the original units, and there is an additional bond for the 44 units?
No, sir. There's no school impact fees on the original, only because they're grandfathered.
Okay.
And then when it was amended to add another 44, the school impact fee, the ordinance had passed, and so only the 44 would be affected.
Help me then, I'm just really thick, I guess.
No?
The bond that's existing,
The bond they
Does-
put in is in advance of a ruling because they could not pull permits if they didn't pay it. So they have paid it, hoping that there would be a determination later that it would not be found appropriate and would be refunded to them.
does the bond directly apply to the 44 additional units?
Only to the 44.
Okay.
Allison, or excuse me, Ms. Harden, when Mr. Wilson was talking, and he said he would ask that he would be agreeable to paying the fees when the 75th garden department, I believe you agreed with that, or you indicated
prefer to
that the
be right.
county would be, pardon me?
I prefer to be right, but that would be an acceptable compromise.
An accepable
Now,
compromise. I
whether
wanted
or
to make
not-
sure that I didn't misunderstand.
Right.
But when you, and not to lead you, was your agreement based on only 74 units being built or other construction go on, and then the compromise would be when they start number 75?
The compromise statement in the report was made with full knowledge that the applicant could build 217 units and leave the last 44 unbuilt completely, because that is always the opportunity of a developer when they come forward, is to make a plan, to start the plan, and maybe something happens and the plan doesn't go forward. That can happen.
Okay,
The
that
reason that
wasn't my question, though.
Oh, I apologize.
I'm sorry. We're all trying to
Okay.
get this right.
I didn't understand the question then.
I don't know if we should ask the county what they're agreeable to, because I don't want you to influence anything more than giving us information. So I'm I'm not sure which way to go. I'm not going to ask you any more questions about that because I don't want to get into an area that we shouldn't. But to be honest, Mr. Wilson and board, I was looking, to be honest, at if there was room for a compromise as opposed to it just has to be paid, and we haven't gotten there yet to whether we believe it should be paid now and left in the bond as you have done, or when you start the 75th one. I am troubled by the fact that that is almost a meaningless statement if 6 cottage court units and 80 townhome units are built. That is, to me, an empty compromise. And I don't mean that, again, in a nasty way, but it just seems like there's no meat on the bones of that if you do everything, which would be exactly saying, we're going to build everything, and then we'll do the fees if it is found that the fees are the appropriate thing to put onto this project.
So, Madam Board Chair, I think I can get you pretty comfortable with that. So order of magnitude, this is a $68 million project. What we're talking about here tonight is when we're going to pay a $385,000 fee.
Exactly.
$68 million project.
Exactly.
I'm
glad you said it because that's what I've been thinking.
It's an important issue, and I'm pleased, I know this is being publicly recorded. $385,000 is a lot of money. But as it relates to the entire project that we're building, it's a very small.
We are on the same page again.
So we would just like for the board to give us relief of when it's paid. But I'm under oath, and I want to answer you truthfully, so you've pushed me to a corner, and we're having this odd discussion. But, Madam Board Chair, it's a $68 million project. I'm pretty sure we're going to build every inch of it and be good tax-paying citizens.
Mr. Wilson, I'm not communicating well with you if you think that I am concerned that you're not going to build anything. I have 100% faith in you that you are going to build 261
Hopefully every one of them, ma'am.
units.
Right.
I don't have any problem with that. My job is to determine when you pay these fees, which, like I said, again, I know you have put them in a bond. And I am just saying that it appears to me that the compromise of paying when you start the 75th apartment is an empty compromise. The emperor has no clothes. You could finish the entire project before you get to paying the bond. So I think we took it, I took it, I interpreted it as, we'll build 74, and when we get to the 75, we'll pay the school impact fees. But by digging, and I had to do a lot of digging, you could build, in your mind, everything else, and then at the very end, come down to that. So if we're going to talk compromise, I would want it put in that a true compromise would be when the 75th garden apartment, when you turn a shovel, then you pay them. But I'm afraid that compromise of when the 75th is built and we're going to keep doing everything else, because that is the way to do business, is not much of an offering.
Except, Madam Board Chair, that when you've created a hypothetical that's so difficult to operate in, we're going to build all of them. That when we say 75th, there's 44 more units. We have to have those.
But we're talking about timing of when you're paying the bond. We're not talking about we're going to build everything, we're going to get there, and we have to do it. This is what we want. 68? Did you say $68 million? 63?
I think order of magnitude, it's about a $68 million project.
I understand all of that. It's just that the word compromise was used, and there's no compromise here. The compromise means we give something up and you give something up.
Madam
We
Chairman.
would be giving everything up if you just built everything and then paid at the end. Excuse me, what?
Madam Chairman, basic question. Your original plan was to build 261 units. Is that, I'm sorry.
17.
217.
Correct, Board Member Jones.
Okay. You build 217. You complete those, and then you start on the 44, and you pay the impact fee then.
Yes, sir.
What's wrong with that? What's wrong with that? I mean, he's already said that this is our original plan.
Let me ask a question, because I don't know the answer on the 44 garden apartments, have you incorporated them throughout this? There's no new building for 44. That's what
that's
the
right.
problem is. That's the problem.
That creates more jeopardy for me, Madam Board Chair, because I've already pulled permits for 5 of the green buildings, and they're sprinkled all through the buildings. I mean, this is imminent.
Okay, but we're just trying to get to the point here. Why? The reason why it isn't is this is not 2 separate projects with 217 grandfathered and 44 new. This is 261 together. So when he is building, he is going to be building those apartments that are supposed to have a school impact fee, if we decide when you come back. Therefore, he would be going against the county ordinance as soon as he starts building these buildings that have those units. If he had just added on to this project another building with 44, we wouldn't be having this discussion. But they are interspersed as one project of 261 now. And according to county ordinance, Ms. Harden, correct me if I'm wrong, you cannot pull permits without paying school impact fees in advance.
Now, Madam Board Chair, the difficult thing, though, is the statute also, this body, Lancaster County, said that 217 were grandfathered.
Yes.
So, again, I'm not trying to argue, I'm trying to
No,
advocate. So if I can't get you
understand.
on my side, I've really screwed up. But what's the point of calling them grandfathered if it's all really one? Why wasn't the school impact fee on all of them?
Well, if
It was
you'd
only
like
on the
that, we can
44.
arrange for that.
Madam Board Chair, I'm sure you would.
We
That
have
would
a
be-
school board
then we'd have-
member sitting behind
I know.
you who
Then
would
we'd
be
probably have to
happy.
go to a higher body to resolve that one. But your point's well taken.
Can I ask a question? And I heard this, and I don't know how I even came up with this question in my mind. Did y'all modify floor plans to come up with 44 more additional one-bedroom units, or did you add 44?
My
Additional units.
understanding, Board Member Jones, is that the 44, we modified 3-bedroom units and we made more 1s and 2s. We thought that this particular area of the county would have people that didn't want as big a
So
unit.
it was a change of floor plans,
It was a change of floor plans, less.
and the number of buildings didn't change.
Number of bedroom, the number
So-
of buildings didn't change and the number of bedrooms didn't change.
And-
It's just I have 44 more doors. And then that triggered.
So I'm trying to figure out how you separate those 44.
You don't. You do
I
not.
don't see how you can.
Well, we have a map. I mean,
I'm looking at it, but in the green, that's where the apartments are going to be, but they're mixed in
Wait, just a minute. Mr. Wilson,
with
this is where,
2-bedroom apartments.
this is where the 44 were incorporated in.
that is correct, Madam Board Chair.
There's a new one over here, and 10 over here, and 6 over here. So it is put together. Part of this is grandfathered, and part of this is not.
And from my point, if it's okay, if I may speak, the joining of those was why it was difficult for us to figure out when to apply the fee. Now, when you talk about joining the entire project, we were not concerned with the entire project because the 63 cottage courts and the 80 townhomes were not applied. So when it came down to it, we considered that the intertwining of the 44 apartments going from 74 units to 118 was the concern. At any time that cottage court and the townhomes are built, they are grandfathered in. I have nothing to say about that for impact fees. It was the section of the townhomes, or the apartments, excuse me, that gave us that was basically the reason that we made the decision.
Madam
I think I
Chair.
got a question for you, maybe one of these gentlemen over here. And,
They have to be sworn in before they can answer.
okay, let me ask a question.
You want to
and
ask the
pick-
question? Yeah, no, see.
And from a project management standpoint, are you using something like Primavera as a project management software?
Yeah, the program that we use, Board Member Jones, it's a modern one called Procore.
I'm an old man, and Primavera was out when
I
I
know,
was.
I know that one too. I
I've
used
been
to
retired 27 years, so that was a long time ago.
I've been doing this 27 years. I remember it.
That's a project software that I remember. Okay, so you know where your construction is phased, and you're not going to go in to just one area, and you're going to have construction going on in multiple areas at the same time.
Board Member Jones, that's exactly right. That's why I was
That's
having
what
a difficult question and answer with the
And,
board chair, because you build the whole thing, it'd be
I was in-
almost impossible to go, okay, well, guys, but stop right here and don't build, this one corner with this one unit.
I guess maybe because I was in the architectural engineering department for 25 years, I have a little more feel for
Who's the
what's going on.
developer?
And
Who's the developer?
Francis is right. The way, if you had come in and said, we're going to build 44 apartment buildings, and each one was going to have its own individual roof, and it was an added to, rather than coming in and modifying the floor plan in existing buildings, it would be easy to separate. It is, as Allison said, it's impossible. And as Francis said, it's impossible to pull out 44.
Correct, Board Member Jones, other than to just say numerically, which is easy to track. How many have you pulled? I pulled this many, boom, and then when you pull
But
the
in this building,
75th.
you pull a permit to build this building, and it's got X number of these apartments, Y number of these apartments. So you pull a permit, and you can go in that building and build away. And me riding down the street, I wouldn't know whether you had built one-bedroom apartment or whether you'd built 44 one-bedroom apartments, because I don't know what's in those buildings.
Board Member Ingram, I think you're going to ask me a question. You're shaking your head, so I feel like I haven't connected with you, but I'm glad to answer any question you have.
I just asked who was the developer.
So our company is Northwood Raven, but we form a different LLC for each project. So, I mean, the human beings that are developer are these two gentlemen right here, Kyle Whitaker and
Hi.
Mr.
Okay,
Ron Stewart. I mean, they go there every
it's
day.
a $68 million project
That's my understanding.
that will
Board Member
probably
Ingram.
generate, a few hundred million in, sales, whatever.
I don't think I can say that
Rent,
under
whatever
oath.
case may be. I'm just saying, because I don't know if you're going to sell them or rent them. Who knows? But the fact of the matter is, when you put $382,000 against $64 million, that's peanuts. Just pay the fee.
That's respectfully, Board Member Ingram, that might be a little more argumentative for the hearing than the rules contemplate.
You can afford it.
We would like to, we will pay the fee. We're just having a debate about when the timing triggers.
We just do it now and be
You will pay the fee? Did you want to go on the record for that?
Well, we have an appeal that's coming up, so that's coming on. The record is, and you have a concern that when we get to the 75th, that somehow it won't be paid. We've already done the bond, so.
No. I
feel like we're arguing, Board Chair. I don't
We're not
think it's an
arguing.
adversarial
We're not
proceeding.
even understanding each other.
Okay.
So you can't argue unless you agree on a point to argue on. I never, at any time this evening, have doubted that they will all be built. I am strictly discussing what we are supposed to discuss on when the payment should be made, which you have already put in. I just feel that the garden apartments that we've talked about have changed. And it is no longer, it's not grandfathered and new 44, it's together. Also, the garden apartments, townhome, and cottage courts, it's all one project. It's not just garden homes. And where I was concerned that you would build everything and then say, and I'm talking about the green, that you would build all the green homes and wait until number 75 and then pay, in the meantime, finishing everything else. I never think you're not going to build. It's too good of an opportunity not to build. But this is all one project that has been grandfathered and then new and then put together. So I feel, my feeling is, if you are building this project and pulling permits, that the fees would be applicable from the beginning.
I understand your argument, Board Chair, and so I would only default back and say we work very well with planning. Planning has presented a way forward, and maybe consider what's in the materials presented to you, that they have said that it would be acceptable to them that if we built the 74, that we would then pay within the garden apartments where it's green when we hit the 75th, and that's from the
And I do
Lancaster.
understand their recommendation, which I'm sure you understand we are not bound by. It is simply a recommendation to this body. Yes, sir.
Wanted to sort through, Mr. Wilson, the cost of that bond. If I understand correctly, a bond would be put out by a financial institution.
Which has already been put out.
And what is your actual out-of-pocket cost for that bond? Can you tell me?
I
could
don't
get
think-
the answer, but I don't know the answer.
I don't think that's relevant, to tell you the truth, and with all due respect.
Several $1,000s, but
Just
thank you
trying
all
to
very
put it
much
in
for your time.
perspective,
Yep.
Madam Chairman.
Oh, I think one of our board members put the $382,000 on the table in
No, I'm talking
perspective.
about actual out-of-pocket
Out of
cost.
pocket now. So,
That's all.
thank you, Mr. Alden. I didn't mean to be disrespectful to your question. I appreciate your participation and questions and comments. Go ahead. Is there any more discussion? Is there a motion?
So thank you. I
Yes,
wanted to
sir.
thank you all very much, and we've preserved for the record the point of the grandfathering versus the 44, and we put that before the board, and thank you all for your time tonight.
Thank you very much,
You indulge
Mr. Wilson.
another foolish question,
Yes?
Madam Chairman.
Certainly not. It's not foolish. Go right ahead.
Mr. Wilson, is it appropriate for him to step back up?
Yes, certainly.
Thank you, Mr. Wilson. I know you needed that upper leg exercise. What I'm trying to get to and what I want to ask, this bond, is it in effect until when? We have a temporary bond, or what, under protest, I think is the right term.
That is
So,
correct. I don't
how does that
have the
go? Does
bond
that
in front of me
go-
right now, but Planning Director, I'm pretty sure that it's in effect for the entire length of the construction, so at any,
You have it in your packet. It's Exhibit 4G.
I'm sure I do.
and that was approved by the lawyer for Lancaster County.
I'm all okay
Oh,
with the
yes.
approval. I just want to make a point in terms of timing.
Same the whole time. Board Member Alden, I think it's in effect until the project is complete, and then it contemplates, because a bond's a legal document, and so it contemplates, and please, if it went all the way like to United States Supreme Court, the money still, it has to stay in effect the whole time, if that makes sense.
Can we trust that?
Right.
No, I'm talking about the Supreme
Yeah, and the bond
Court.
says,
Sorry.
yeah, and your very capable planning director is pointing out to me, it says that it has to stay in effect until we, the petitioners, have exhausted all administrative rights, remedies, legal appeals proceedings. There's no risk that the money goes away.
Okay, that's the point I'm trying to make. So if we procrastinate, subject to statutory problems, if we procrastinate, that bond's going to remain in place. Is there any opportunity for the applicants to bail out of that bond?
None.
Okay. Thank you.
If there are further questions, please bring them forward. If not, if someone would want to make a motion, and we just ask that the motion is made in the affirmative to put it on the table, and then voting can be for or against the approval.
Madam Chairman, I make a motion that we approve the applicant's request to postpone paying the bond. I'm paying the fee.
Until? He has put forth until the 217 are done, or the 75th? So the 217?
217.
All right. Could we have a second? Second? Mr. Alden. All in favor of granting the appeal to pay the fees after the completion of the original 217 grandfathered apartments, raise your hand. All not in favor, all those in favor of denying the appeal? I'm sorry?
Our motion is to approve at the time that 217 have been built.
Yes.
We have one for that and the rest against.
We haven't voted yet. We have one yes, we haven't voted the denials yet.
A denial would be a separate motion. We're voting on whether we approve
Right.
of building after 217. Only one person agreed to that, which means the others do not.
Most likely are going to say do not. Is that what you're saying?
No.
Okay.
Denying is a separate motion. We're voting to approve. If you didn't vote to approve, then you voted to deny.
Okay. Thank you.
So Mr. Alden voted to approve and everyone else voted against.
Okay.
So
now we
that
need-
motion failed.
So we need a motion to
4-1.
deny. Is that correct?
If you
If
You
that's.
don't need another motion to deny.
Oh.
The motion to approve failed.
Okay.
That equals denial.
And then we are finished.
Yeah.
Okay.
So if your vote is vote to approve, Gary Alden voted in favor, the rest of you voted against, then the vote is 1-4. The vote to approve is 1-4, which means the motion fails.
Okay. I was
Now,
going to allow
if
for
someone,
extension.
if someone else wishes to make a motion to approve after building 74 garden apartments, that is a separate motion. But you made the motion in the affirmative. You don't need a second motion to deny.
Thank you very much. Are there any other motions that you would like to bring forward? Seeing none,
Seeing none, then the motion is denied.
the motion is denied, and the bond will stay in place at this time? All right. Thank you very much, Mr. Wilson, and council and vice presidents. Thank you very much.
As a point of procedure, who seconded the motion? Right. He made the motion. Who seconded?
Seconded by Mr. Alden.
Okay. Thank you.
And where are we? Let's see, So we are new business. Do we have, let's see, our next meeting will be in October.
Next scheduled meeting is October because our September meeting is canceled because we scheduled this for the end of August, and we felt that would be in lieu of September. Next scheduled meeting is October 6th, I believe. We are trying to get confirmation of a training session then. We don't have a date yet. We are in contact with the trainer, but we don't know yet. Now, it is possible they may not be available on the 6th, so it may be a different Tuesday we're trying to keep it on a Tuesday, maybe a different Tuesday in October, but we will have to keep you posted about that date.
Jennifer, that date is actually, I believe, October 3rd.
3rd, is it the Tuesday? The first Tuesday is the 3rd? Okay.
If everyone can try to keep their Tuesdays open, just in case we would have to move the meeting to a different, or training to a different. Do we have anything on the agenda yet?
We do not have any cases submitted for board consideration, so it would solely be a training.
Okay.
I have not heard from Beverly.
2 meetings in a row that we,
I don't know. She has not responded to emails.
did she respond last month?
I can't
Okay.
recall.
So we have next month's agenda and the date for the group training. If there's no further business, could I have a motion to adjourn? Ms. Lowry, Ms. Ingram? And, oh, wait, just a moment.
Just a moment. So do we have acclamation
Oh.
that we are
do a
adjourned?
Vote to
Okay.
adjourn, yes.
Okay.
Unanimous.
And let me end the live stream before any other discussion takes place.